move that the question be now put.
I'm going to hear from Carol Beaumont.
Thank you very much, Mr Chair. It is actually a privilege to rise to speak this bill. I've listened to all of the contributions so far on this bill, and I have to say there have been some extremely interesting and very thoughtful contributions made by all of the speakers tonight on the Legal Assistance Sustainability Amendment Bill, and as others have noted, now being renamed the Legal Assistance Amendment Bill. And I guess I'll start by saying that despite changes, and a number of people have commented that, if you like, this has been clawed back to something a little better, that it still doesn't mean that this is a bill that we can support. And Labor does oppose this bill, and we oppose it because the net effect is still a denial of access to justice. And as others have more eloquently put than I'm sure I will be able to, representation is fundamental to access to justice in our system. Having access to legal representation is vital, and so many people are not able to represent themselves, are, for a range of reasons, perhaps even unaware of their own rights. And so having decent representation is fundamental, especially when the consequences are potentially very significant, whether they be financial penalties or loss of liberty. The fact of the matter is that people can suffer very severe consequences, and they have the right to have access to justice and decent representation. Now, we oppose this bill because it still places a number of limitations on New Zealanders' rights to access to justice. And it's part of a concern that we have about the general direction of the government in relation to the justice system. And the bill, as originally introduced, and certainly the contributions from a variety of people on that, have been very interesting in realising the full extent of what was proposed and how serious those changes were. And my colleague, the Honourable Leanne Dalzell, does make the comment that the Minister, rather than members of the committee from the other side of the House, was probably most likely to be responsible for the improvements that were made. And there's a significant number of pages, in fact, of changes made under Supplementary Order Paper 134. But despite that, there are still a number of significant areas that we are concerned about. And if we sum them up, they are in four main areas. Firstly, that the application for legal assistance may be turned down if the applicant is in arrears for repaying any part of a previous grant of aid that he or she may have received. And I think it's important that we look at this in the context that New Zealanders are currently living in, which is that it is extremely difficult for many New Zealanders to make ends meet, that actually the budget doesn't stack up for people, and the income that they have and the expenses they have. And frankly, it is quite likely that people will be in situations of not being able to repay arrears because they're trying to live. And if you talk to budget services, they will tell you just how hard people are struggling. So that's the first of the four main concerns. The second one is that the reintroduction of a user charge, although the figure has now been reduced, is still a concern. Thirdly, the provision that interest is to be charged on arrears of legal aid. And fourthly, the provisions having retrospective effect. And so those are the four main areas that we're concerned about. And I'd just like to say that the Minister talked about, and somebody else has mentioned this, but the Minister talked about people being concerned about seeing white-collar criminals, you know, the finance company rip-off merchants using legal aid. But the fact of the matter is that is not overwhelmingly who uses the legal aid system. And I want to also refer to the regulatory impact statement. The Honourable Leanne Dalzell referred to it earlier, but I want to particularly talk about that it's not white-collar criminals, it's not middle-aged white men who are going to be hurt by restrictions and the denial of access to justice. And let me just reread that one sentence, really, two sentences, sorry. Restrictions to eligibility will disadvantage people on low incomes who have few options to find legal services elsewhere, Generally, this includes young Māori men in the criminal jurisdiction and women and children in the family jurisdiction. So even with the changes, it will still disadvantage those people.
John Hayes.
I move that the question be now put.
The question is that the question be now put. Those of that opinion will say aye. To the contrary, no. The ayes have it. Ayes have it. Party votes called for. Ask the clerk for a party vote.
New Zealand National.
59 in favour.
New Zealand Labour.
33 votes opposed.
Green Party.
14 votes opposed.
New Zealand First.
7 votes opposed.
Māori Party.
2 in favour.
Mana.
1 vote opposed.
Act New Zealand.
1 in favour.
United Future.
1 in favour.
Brendan Horan.
1 vote opposed.
Any other votes?
Members, the ayes are 63, the noes are 56. The question will be put. We first have the Minister's amendments as set out on SOP number 250. The question is that the Minister's amendments be agreed to. Those of that opinion will say aye. To the contrary, no. The ayes have it. Party votes called for. Ask the clerk for a party vote.
New Zealand National.
59 in favour.
New Zealand Labour.
33 opposed.
Green Party.
14 votes opposed.
New Zealand First.
7 votes opposed.
Māori Party.
2 opposed.
Mana.
1 vote opposed.
Act New Zealand.
1 in favour.
United Future.
1 in favour.
Brendan Horan.
1 vote opposed.
Members, the ayes are 61, the noes are 58. The Minister's amendments are agreed to. The question now is that Part 1 is amended stand part. Those of that opinion will say aye. To the contrary, no. The ayes have it. Party votes called for. Ask the clerk for a party vote.
New Zealand National.
59 in favour.
New Zealand Labour.
33 opposed.
Green Party.
14 votes opposed.
New Zealand First.
7 votes opposed.
Māori Party.
2 opposed.
Mana.
1 vote opposed.
Act New Zealand.
1 in favour.
United Future.
1 in favour.
Brendan Horan.
1 vote opposed.
Any other votes?
Members, the ayes are 61, the noes are 58. Part 1 is amended, will stand part. We now move to Part 2. This is debate on clauses 23A to 53. The question is at Part 2 stand part. The Honourable Leanne Dalzell.
I wanted to